Right. Good afternoon, everyone, and welcome to our October edition of In the Boardroom with Atollis Law, featuring attorney Andy Phillips. I'm actually very excited about this month's In the Boardroom, where we're going to talk about County Board Rules template. For those of you who don't know, and I don't know if Andy will mention this or not, but he and I have been actually talking for years about creating the ideal set or a template of county board rules. And so that has finally been accomplished. So I'm actually really excited that Andy and Malia today are able to join us and talk about the county board rules template and how it is that your county could benefit from utilizing this template and creating a really good set of county board rules to guide your governance structures moving forward. So before I turn it over to Andy and Malia, I just want to make a couple of quick announcements. First, this webinar is being recorded. The recording, along with the handouts from today's session, will be placed on the WCA website. Typically, we have it posted within a few hours after we have completed the webinar. So, and I'm anticipating that we will get it posted by the end of the day today, if not first thing tomorrow. The second thing I just want to mention is if you do have a question during the webinar, we ask that you use either the raise hand or the chat feature within Zoom to ask your question. Andy and Malia, along with myself, we will be monitoring the chat in the Q&A session or sections throughout this webinar. And so we will try to get to questions as they arise. But sometimes we fall a little bit behind and want to make sure we get through all of the material. And in that event, we will pick up any questions we may have missed along the way at the end of the webinar. So at that point, before I turn it over to Andy, I want to welcome Malia Malone. Malia, this is your first appearance on In the Boardroom, so welcome to you. And while I'm hoping it is your first appearance, this is not the first time you have participated in the boardroom, given your previous work with Polk County. So with that, welcome Malia and Andy. I think I'm turning it over to you.
Thank you, sir. Good afternoon, everybody. Awesome topic. Awesome to be back in front of the screen after taking a month break while we had the annual conference down in La Crosse last month. As Sarah mentioned, the freshest face that had told us is joining me today, Malia Malone. She has significant experience with county government, having been the Polk County Corporation Counsel for 18 years. And so she has been to over 100 county board meetings in her career. So she's going to bring some practical experience to my philosophical discussion about the board rules template. I think many of you might remember that last year I think it was December, we did a two-part series on county board rules. We did that in December to gear everybody up for consideration of updates to their board rules and even adoption of board rules leading up to the spring election. I can tell you that having traveled across the state with Sarah, having discussions with counties about various topics, primarily roles and responsibilities and things of that nature, the topic of board rules seemingly comes up all the time. And so board rules are something that counties should use, are not required to use. There's no statute saying that we have to adopt board rules, but counties should use to establish a framework for how counties are going to interact at the board level, interact between board and administration, and also how they're going to govern themselves procedurally in the conduct of their board meetings and their committee meetings. So before I start, as Sarah mentioned, let me just tell you that this is designed to be an interactive discussion. In the boardroom is where discussions take place, debates take place. So feel free to liberally use the chat and Q&A functions on the monitor so that we can get to your questions or we can have discussions about particular topics. This is not going to be a PowerPoint presentation. We actually have the board rules, the template board rules that were distributed on the screen, and we'll walk through what all of those rules are, the various choices that you may have in adoption of your board rules, and then otherwise answer any questions. So before I begin, anything that you want to say, Malia, because Sarah and I have been talking all about you. You've not had a chance to talk.
Well, I'm just very excited to be a part of this webinar and to be on this side of it instead of the other side. And working with Wisconsin Counties Association is a great way for all of the counties to kind of have a general sense of how they're going to set out their board rules so that they can have a functioning board for the next term. And so I think this is a great topic, and I'm happy to help and offer any insight I can.
Awesome, thank you. So what do we want to accomplish today? Let me just set the foundation here. As I mentioned, we're going to go through the template item by item to understand what it does and perhaps what it does not do. But overall, I think it's important that we have a solid understanding of what the county board rules do. What they do is they establish, as I've mentioned, the foundation for the relationship between the various components of county government, and especially the relationship between board members when it comes to board and committee meetings. I will tell you that having worked with school districts in my career as well, the difference between school districts and counties is huge in terms of the way they treat governance. From a school district perspective, all of the school boards in this state have adopted policy sets, and they're very, very lengthy documents. There is a board policy on almost anything you can think of relating to school district governance. Counties are not like that whatsoever. I don't know why that is. It's just something that has evolved over time. And so when we see school districts operate in an environment where policy governance is critically important and counties not, you can see that there are benefits to both sides, but hopefully we're going to take what's good from both sides and implement that in practice so that we can avoid consternation, disputes, disagreements, what have you, in our board and committee meetings. We, of course, have the freedom under 5903 of the statutes. I think a lot of you have heard me talk about that statute in the past as the freedom statute. That's the freedom statute that allows counties to organize their administrative affairs as they see fit, subject only to a statute of statewide concern. And so what 5903 authorizes is for your county to take a look at the rules governing governance and adopt rules consistent with the expectations that you have and consistent with the expectations that your citizenry and community have. Board rules are not one size fits all. I hesitated in naming this document a template because it's not simply a cut and paste exercise. I think you have to think about what each provision does and think about how you want to fit a particular provision within your board rules. And so I really caution you to work extensively with your corporation counsel to make sure you have a solid understanding of the rules, what they do, what they perhaps don't do before you implement them. There are any number of procedural issues that come up during the course of your meetings that hopefully are addressed within your board rules. Again, our effort here is to be proactive, to anticipate issues and resolve those issues before they even occur. That said, I guarantee you that there will be procedural issues that occur within the context of what you think is the most perfect set of board rules ever. There are still going to be issues and concerns. So it's very, very difficult to resolve everything up front. Nonetheless, if we can take the majority of issues that are going to arise and deal with those issues in our board rules, I think we'll find that we have much smoother board and committee meetings. I want everybody to think about how business is transacted in your county. Think about the improvements that you can make, and then think about what is it that we can do within our board rules to try to assist in making those improvements. So with that, perhaps I'll start with the template. And we start, of course, with a table of contents. This is up here, and I want to talk about this briefly, just so you have a framework for the rules and what we're going to do. Last December, when we went through, there were two parts, and those are available at the wicounties.org website if you want to take a look at those discussions. But what we did is we talked about the framework. In other words, what do we want our board rules to include? The primary sections, at least in my mind, are county board organization, section 2, and then we have some rules within section 2. We have county board officers in section 3, and then we have our rules of procedure in section 4. And so as we go through these rules, of course, we're going to talk about each section, the rules contained within those sections. But I think looking at it this way gives a good organizational form to what it is that you want to address within the context of your board rules. Why is that important? Well, it's important because I think that the community, your board members, your committee members, everybody has a set of expectations going into a meeting. And if you define those expectations by your board rules, I think you'll find that it's much easier to conduct your meetings. Everybody understands the ground rules. In other words, when we have 22 players rushing onto the football field, they all understand that grabbing somebody's face mask is going to result in a 15-yard penalty. That's an expectation. We know that. So let's define what these rules are, define what kind of conduct, what type of governance is in bounds, and what type of conduct and governance is out of bounds. That's what we do within these board rules. So we have purpose and definitions in section 1. This is pretty basic. I'm not going to spend a lot of time here. The important part here, at least from my perspective, is that we adopt the board rules here as the rules of the county board, and that in terms of interpretation, it's important to understand what takes precedence over another thing. In other words, we know that federal law takes precedence over state law, which takes precedence over board rules, which takes precedence over Robert's Rules of Order. So again, in interpretation issues, we know what takes precedence. And then we get into this concept of county board organization. And let me pause for a moment and say, Malia, jump in whenever you feel the need to jump in. I have a tendency to talk a lot, I think, as most people know, but feel free to jump in, either correct me, do that gently, or add to whatever it is I'm saying.
Absolutely.
We have these county board meetings. By statute, by law, we have to have an organizational meeting. We know by law that happens on the third Tuesday in April after the election. So that's an even number of years. In the statute, it says that the organizational meeting, we can organize and transact general business, but it also says that we have to elect our officers. We elect our board chair and we elect our vice chair. So if we look at the organizational meeting, those 3 elements, those are required. That's in statute. When we get down to the option, this is what I've seen other counties do at their organizational meeting. Counties have looked at appointing committees at the organizational meeting. There are a variety of ways by which committee appointments are made among the various Wisconsin counties. I've seen committees on committees organized for purposes of making committee appointments. I've seen the board chair appoint committees subject to board confirmation, and that's the process in 59.13 of the statute. Or there may be some other process that the board utilizes for purposes of appointing committees. Again, when we talk about what's contained within this board rule, we look at the organizational meeting and we address the committee appointment process at the organizational meeting. Why is it important that we address this at the organizational meeting? Well, we know that counties don't just stop when the election happens. The business of county government continues. And so the business of the county board continues through the election process, through the organizational meeting process. So it's important that we have committees appointed and seated as soon as possible so that counties can get done what they need to get done. So even if you don't do it at the organizational meeting, our general advice is going to be get it done as soon after the organizational meeting as you can.
So when you're looking at committees and assuming that the committee structure stays the same between one county board session and the next at the organizational committee, some thought should be given to whether or not tenure on a committee is something that the county board values, if they want to keep that institutional memory to give those county board members that have previously served on a particular committee sort of the right of first refusal to go back to that committee. That's something that can sometimes be difficult, especially when you have a new board member that comes on the county board and maybe they were running on a few specific key items and they really have a desire to be on a particular committee to draft some policy and to steer the county in a particular direction. So putting thought into that ahead of time is important.
Yeah, that's a good point, Malia, because it brings up this concept of term limits when it relates to committee involvement. I've seen some counties have term limits baked into their board rules where a person can serve on a committee for no more than 3 consecutive terms, 6 years. I don't have a particular preference one way or the other. I mean, I think that can be beneficial. I also think it can be detrimental. It depends on the circumstances. It depends on who the person is that gets term limited off the committee. So again, to Malia's point, that's a consideration when it comes to committee appointments on whether you include rules that relate to service on the committees. The question that comes up, I've seen before too, is who chairs this organizational meeting? You could have the incumbent board chair serve as the interim board chair at the organizational meeting. It's called in Robert's Rules, the chair pro tempore, chair pro tem, whatever we want to call it. You could do that. I have a bit of a concern about that because we don't want to presume that that board chair is going to win the next election. And it's odd that the board chair would serve as board chair pro tem, conduct the nomination process, conduct the election process when the board chair, him or herself, is running for that board chair seat. And so often we like to see disinterested persons sit in that seat. When I say disinterested person, somebody who's not interested in the outcome of officer elections. I will tell you that some counties utilize a board member who's not running for board chair. Other counties utilize the county clerk. Some use corporation counsel. I've had the privilege of serving in that seat for organizational meetings in the past. It was a blast. If any county wants to have me back, I'd love to do it. It was a lot of fun. But have somebody disinterested in the election, in the outcome of that election, sit in that chair pro tem seat. After the organizational meeting, there are two sets of meetings, actually three sets of meetings here that we talk about further in the board rules. By law, in 5911(1)A, we have to have an annual meeting that happens in November. And so we know that the annual meeting has to happen. And when we think about it historically, I think there were counties that frankly met for the organizational meeting and the annual meeting every year, and that was it. They didn't have meetings in between those two meetings. That's going way back, obviously, before the business of county government got incredibly complicated. But the annual meetings required by law, so we have to have that in the board rules. Then we have regular meetings. I think it's good to set a schedule for regular meetings. Whatever that schedule is up to the county. If you want to modify that schedule during the summer hours, for example, to provide night meetings during the summertime, you can do that. I mean, I've seen counties do it a variety of different ways. No matter how you do it, let's put the regular meeting schedule here in the board rules. And if the regular meeting schedule is something that might be changed every couple of years, then just note in the board rules that the schedule is going to be adopted at the organizational meeting for the current term of the county board. So again, let's just address that within the board rules. And then we have special meetings. We have a statutory provision that allows a majority of supervisors to petition the chair and the clerk for calling a special meeting. Beyond that, there are different counties that do different things in terms of the ability to call a special meeting. Do we want to allow the board chair to call a special meeting of the board? Do we want a board chair and a particular number of supervisors to be able to do that? Do we want a particular committee to be able to do that? Whatever that is, whatever that mechanism is, let's put it here in the board rules. Personally, I think it would be good to have a mechanism separate and apart from 5911 sub 2, so that the board chair or a specified number of supervisors can call a special meeting, because the petition process is a bit cumbersome as it relates to calling special meetings, but that's entirely up to your county. Next, we have county board meeting agenda responsibilities. I get asked this question all the time. Who controls the agenda for a county board meeting? Well, by law, it's the board chair, all right? But that doesn't mean that the board chair has final say on everything if your board rules provide a process for getting items on the agenda. And so you'll see here some suggested language. Board chair in consultation with the county clerk and perhaps the executive administrator or administrative coordinator is responsible for the contents of an agenda, except unless a majority of the supervisors petition for a special meeting and dictate what that agenda looks like. Regardless, even if you want the board chair to consult with the committee, if you want the board chair to get, if you want a committee responsible for the, whatever the process is for setting the agenda, again, let's put it in the board rules. I will tell you that in 5923 of the statutes that the county clerk has responsibilities as it relates to the agenda. I will tell you that under the open meetings law that the board chair is ultimately responsible for providing public notice of a county board meeting. And so the board chair and the county clerk have to be involved in some fashion in this process. But beyond that, if you want to define the process of who's responsible for the agenda, then you put that in your board rules. And that gets into subsection B here in the town. What if somebody wants something on the agenda and the board chair just flat out refuses to put it on the agenda? There's a process to get something on the agenda. Under Robert's rules, of course, the body, the county board, controls the agenda for the next meeting. If the county board, the body, directs the chair to do something with the agenda for the next meeting under Robert's rules, the body can direct the board chair to do that. But what's the one thing we know about Robert's rules that is a constant? And that is that these board rules can modify what's contained within Robert's rules. And so if you want a board rule in place that dictates how things get on the agenda, let's put that board rule in place. We have a process for distribution of meeting materials. I think that's important too. Let's establish some deadlines so that committees have an understanding of when they have to submit materials for the county clerk to be included within the board packet that gets distributed in anticipation of a board meeting. It's up to you as to what that process looks like. It's up to you as to the deadlines contained within that process. It's up to you as to who should get copies of these materials that are being submitted for board action. Define that within your board rules.
Well, I think that's when you're defining those steps within the county board rules, it is key to make sure your county clerk has buy-in because they're ultimately the ones that are going to have the headache of those last minute things, those things that maybe are late and they're trying to look at amending agendas. So if you can work with your county clerk at the outset when developing the board rules and what's going to work best, then you're going to have a much better ongoing working relationship between the board and the county clerk.
And as long as we're pausing for a second, Robin asked a good question. The question is, some board members disagree on word interpretations. Any suggestions on how to deal with that type of thing? Word interpretations of what created the legal profession. I'm just telling you flat out, we wouldn't have a job if we didn't have word interpretation issues. I don't know that you can resolve every conflict on interpretation within your board rules. That said, I think having Corporation Counsel intimately involved with this process will help a lot. Corporation Counsel is accustomed to dealing with these types of interpretive disputes and will guide you, your board, your committees through the process of putting together board rules that are less likely to lead to interpretive concerns. And so I would really, really encourage you to work with Corporation Counsel a lot on your board rules.
Well, and if there's a disagreement and someone does call for a point of order and the chair addresses it, the chair certainly should be relying upon their corporation counsel to help them in answering those points of order.
This next rule is an important one in my mind too, and I think it's near and dear to the heart of every county lawyer that's out there. County email addresses, we only communicate through county email addresses. When you take your seat on the county board, you will be issued an email address that says @yourcountyname.gov. We only use that email address for official county business. Why are we giving this advice, Malia?
Well, because we don't want a walking quorum. We don't want a public records request where we're relying upon county board supervisors and their personal email to determine whether or not they're conducting county business.
That is a great answer, Malia. That's perfect. You are making everybody's job a lot more difficult if you utilize an email address that is not your county's email address, because when that public records request comes in for all emails, we don't want to have to scramble around to 15 different email addresses to gather information. It puts the burden on us, and frankly, it puts the burden on county board supervisors as well. We'd rather just go to IT and say, pull the emails from this particular date to this particular person. That's a lot easier. So we really like this board rule. Next, we get into 2.04, where we get into committees of the county board and other boards and commissions, creation and existence. And it's impossible to try to list out all of the various alternatives that exist for committee structure within county government. If you look at all 72 counties, there is not one county that does it exactly the same as another county in terms of committee structure and makeup. And that's okay. That's the way it should be. Again, your county governance reflects the values of your board and your community. And so it's impossible to try to put a template together. That said, we know that there are 3 basic different committees that exist within counties. First are the standing committees of the board. Those are the board's committees. Those standing committees are going to be populated consistent with our board rules. Instead of putting them in the board rules, we have here designed an Appendix A that serves as the guide for the committee population, what the committees are, and so on. We don't have a sample Appendix. Well, we have a sample Appendix A if you want to see another county's example of Appendix A. But the reason we do this as Appendix A to the board rules is because you want to be able to modify Appendix A from time to time without opening up your entire set of board rules. What do I mean by that? Well, you may say, well, look, if we combine these 2 committees for the next session of the county board, we think that's a really good idea, but we don't necessarily want to have to hit the 2/3 requirement to modify these board rules. Okay, so then you can modify Appendix A without having to reopen your entire set of board rules. Again, standing committees, I think, change over time. Their function changes over time. The statutory purpose of some of these committees changes over time. And so we want to be able to modify our Appendix A consistent with all of those considerations. Then we have ad hoc committees, and those are just as they suggest. Those are needed from time to time to address special issues, and we want to make sure that we don't have ad hoc committees becoming a permanent feature of the county board committee structure. What I mean by that is if you look at, just pick any county that's out there, look at their website, look at the committee list, and some of those counties are going to have 47 committees on that list. Do we really want a system that recognizes 47 different committees? No, absolutely not. That's unmanageable. And so we want to make sure we designate or differentiate between those standing committees, which are a permanent feature of our county government, and those ad hoc committees, which are formed for a special purpose. And then see, we have other boards and commissions. There are other boards and commissions, some required by statute, some that just are created by the county that exist independent of the standing committees and the ad hoc committees. I'll give you an example. The Human Services Board that exists independent of a standing committee and an ad hoc committee. That Human Services Board is mandated by 46.23 of the statutes. And so we want to identify those other boards and commissions. This subsection D here, let me pause here. Malia, you have some experience in this area, obviously, dealing with your Polk County years. Thoughts on committee structure and the way that you address those within the board rules?
Oh, well, what Polk County has historically done, because we transitioned during my tenure there from an administrative coordinator form of government to a county administrator form of government. And at the same time, we dropped from 23 county board members down to 15. So over the course of that time, the number of committees lowered, but the responsibilities within each of those committees was expanded, but then they answered directly to the county administrator rather than supervising departments more directly under the administrative coordinator. So there's been an evolution. But most recently, the question of tenure has been the biggest one, and whether or not we want to give sort of new blood, new county board members, the ability to work their way onto some of the more, I don't want to use the word necessarily popular, but the ones that are addressing issues that are of key concerns for these new county board supervisors. So having a way that kind of balances those two is something that county has been focused on, and I think has done pretty darn well.
Thank you. And we have a question from Conley, who asked about backing up to the conversation on agendas. Does the amending of an agenda and involvement of the county clerk involve both board meetings and committee meetings, or would that be clarified in the rules? Conley, I think you want to clarify that within the rules. I will tell you that there's a distinction in 59.23 as it relates to board meetings versus committee meetings. So I'd encourage you, I'm not going to do a deep dive on the clerk's responsibilities under 59.23, but I'd encourage you to take a look at that statute and then make sure whatever you put in the board rules complies with the statute, but then also reflects the process that you want to have in your particular county as it relates to amending an agenda. Subsection D here is an italicized and bracketed font. Whenever you see italics and brackets within these template board rules, understand that represents a choice or option for the county. And it just meant that we weren't comfortable making a solid recommendation because there are a variety of different ways that you can go with that particular issue. But here in sub D, we have a rule that says the board chair may serve as a member with full rights and privileges of any committee if there's not a quorum present at any committee meeting. I've seen some counties do that. I've seen some counties not do that. Don't really have a preference one way or another, but I think some counties would tell you that that's a way to ensure that they have quorum present at a variety of different committee meetings. And so they want to give the board chair the ability to sit in the seat of a missing committee member, if you will. Next, we get into 2.5. How are committees seated? How do they get on these committees? Again, as I mentioned, as it relates to the organizational meeting, there are a variety of ways that committee members are seated, and 2.05 is the opportunity to explain those different processes. Some counties use a committee on committees, some use a board chair with board confirmation, some use a completely different type of process, and whatever you choose in your county is just fine. Again, the important concept being to put it into your board rules. So again, I'm not going to spend a lot of time on that because I think that everybody has a pretty good understanding of how committees are comprised at your county. Agenda responsibilities as it relates to committees and other boards and commissions, not the county board. This is dealing with committees and other boards and commissions. Committee chair serves as the chair of the committee and is responsible for the preparation of agendas. That's not something that is made up from whole cloth in these board rules. That is a provision in the open meetings law. So the committee chair has ultimate responsibility for providing notice to the public of the existence of a meeting and what's going to be discussed in that meeting. The clerk, in consultation with the committee chair, is responsible for compliance with open meetings laws that relates to posting, publication, and so on. And so again, we see the role of the county clerk in the preparation of the agenda and publishing notice of that agenda. Here we have a process for how a matter gets on that particular committee meeting agenda. And then we have a process where in the first meeting of a committee following the organizational meeting, the committee can adopt dates and times for regular committee meetings. So why do we have this here? Why is this important? Well, I think too that it can be awfully confusing for a member of the community, member of the citizenry, to understand when certain committee meetings, when certain board meetings, when are those happening? And so the more we can establish a regular schedule for committee meetings, I think the easier it's going to be to set expectations with the public. I think the easier it's going to be to make sure that the business that has to get done gets done before a county board meeting. And the easier it's going to be to avoid conflict between various committee meetings. And so I think having a process for establishing regular committee meeting dates, having a process for getting the information out about those regular committee meeting dates is an important concept that you want to put within your board rules. Tom asked a question, can we go over whether a board chair can also remove a committee member? I will tell you, Tom, that as a matter of law, the power of appointment carries with it the power of removal. In the template board rules, we have a process for removal of committee chairs. We also have a process for removal of committee members. And so you can absolutely define within your board rules how that process happens. And I would highly encourage counties to put within their board rules the process for removal of a committee chair, process for removal of a committee member. You can leave that to your board chair and board chair's sole discretion if that's what you want to do. And again, if your board rules say that your board chair appoints committee members, the fact that your rules are silent on removal means nothing, because the power of appointment, again, carries with it the power of removal. So I would really encourage you, Tom, to take a look at the removal process within your board rules. We have a question from Kathy. If the rules list all the committees, other boards and commissions and defines their membership and terms, then what purpose and benefit, if any, is there to also include the same information in a county's general code? Great question, Kathy, because the question is, what is within your county's general code? Are the board rules codified in ordinance? I will tell you that based upon my experience, it's not required, but I would highly recommend that counties put their board rules into ordinance. The reason we do that is that if it's in ordinance, the general public is on notice of what's contained within these board rules. As well, if we have an enforcement issue, which we'll get to much later in the conversation, we're enforcing a county ordinance and not simply the standing rules or board rules of a county. So I really prefer that counties codify their board rules. Malia, do you have any thoughts on that?
Well, I know that Polk County does include the county board rules of order in the code. And what's helpful with that is because as boards evolve and change and the rules evolve over time, it's hard for the public perhaps to know where can I go to find the most updated information as to how the county board runs, and having it in the code with a notation if there's ever been updates, and having that specific place to go rather than, looking at an old version and assuming that the rules are just in perpetuity. Having it in a code can be helpful in that way, just for transparency with the public. But I also wanted to go back to the topic of setting committee meetings at regular intervals, or perhaps once a month, or something more frequent or less frequent, but doing that and talking to your county clerk. If there's no business for a committee to handle or insufficient amount of business to necessitate a meeting, it's a lot easier for your county clerk to cancel a meeting than it is to scramble and put a meeting together if you don't have them scheduled at regular intervals.
100%. Yeah, so establishing that regularity within your board rules, I think, provides the public with adequate notice, lets the public know what's going on. And then also there's a process for just removing an item from the calendar. It's simpler to remove it from the calendar than scramble and put something together. Great point. Here we get into board member compensation 2.07. Here's the first recommendation. It's not in 2.07. First recommendation I'm going to have, and that is, if you've not already adopted an ordinance making yourself a self-organized county under 59.10 of the statute sub 1, do it. There is absolutely zero reason why you would not do that. You don't have to take advantage of any of the benefits of self-organization if you have that ordinance on the books. But if you don't have that ordinance on the books, you cannot take advantage of any of the benefits, regardless of when you want to do that. One of the benefits of self-organization is that you get to establish as the board how your board members are going to be compensated, whether it's going to be on a per diem basis, or it's salary basis, flat fee, whatever it is. You get to decide what compensation looks like. If you do not make that self-organization election, then you are confined by the compensation requirements of 59.10 of the statute. So again, I would highly encourage every county to adopt an ordinance indicating that they are self-organized. If I remember right, and Sarah, you can correct me if I'm wrong, I know you're not on camera, but I think it's well over 45 counties that have adopted a self-organized ordinance. And I think we have the list at WCA. I know I have the list, but I think WCA maintains that list as well in terms of the counties that have elected to be self-organized. To be self-organized, you just have to adopt an ordinance, and all the ordinance has to say is we elect to be self-organized under 59.10 of the statutes, file that ordinance with the Secretary of State, and then it's done. And so if you have questions about whether your county is self-organized, reach out to Sarah at WCA, reach out to me or Malia, and we can consult the list and let you know if you're self-organized. Why is that important?
Oh, Andy, I was just going to answer your question quick. My last count was 52 counties.
52 counties. So when I said well over 45, I was absolutely on the spot. So give me a gold star for that, Sarah, if you would mind. 2.07, board member compensation. The board rule dealing with compensation, the self-organized status is important for this discussion in 2.07. Whatever our compensation system is within our county for board member compensation, let's put it within our board rules. How much are we going to get for board meetings, committee meetings, other meetings? How much our board chair going to make? What's our expense reimbursement process? And the process may change over time. And so you'll see right here within the board rules that we have the ability within the committee structure to delegate responsibility for establishing policies on expense reimbursement to that committee. And I think that's important because we know that the mileage rate, for example, with IRS rules changes from time to time. Do we simply want to adopt the IRS schedule, or do we want to have a different schedule? Does our expense reimbursement policy for board members, does that mirror our expense reimbursement policy for employees and staff? All of those questions, I think, are solid questions, but they belong, in my mind, at the committee level, not necessarily the board level, where every time we want to modify that policy, we have to reopen these board rules.
One thing I would note about compensation outside of just expense reimbursement is I would recommend that the previous county board, the outgoing county board, is the one that's going to set that level of compensation, whether it's a salary or some other mechanism to compensate county board chairs, other county officers and the supervisors themselves, just so they're not increasing their salary or their compensation in the middle of a term.
Not only is that recommended, that's required, Malia. That's a very good point. By law, you cannot modify your compensation mid-term. And so it's important that whatever changes you implement in terms of how much people are going to get paid, and that's not necessarily expense reimbursement, that's a different issue, but pure compensation, that has to be done before, I would say before nomination papers, although there's an argument that that type of discussion can happen before somebody is seated as a county board member, but I would recommend before nomination papers are taken out. Meeting minutes. And this is, again, a very important provision to review with your county clerk. Your county clerk under 5923 is responsible for minutes of all meetings, whether it be your county board or your committees. That doesn't mean the county clerk can't delegate responsibility for taking minutes at committee meetings to somebody else within county government, whether it be a deputy clerk or a department head or a staff member to take minutes. But ultimately, the county clerk is responsible for all of the minutes of these meetings. It's important in my mind that we have one person responsible for all of these minutes, whether it be board or committee, because we want continuity. We want regularity. We want to have an understanding of form and format. We want to know what's included in the minutes. We want to know what's excluded from the minutes. And if we have 15 different people taking sets of minutes, we're going to have 15 different results as to what those minutes look like. And so I think it's really important that counties have ongoing discussions with their county clerk about what is required in the minutes and what people want to see within the minutes. Here we have the process within the county board rules as to how those committee meeting minutes, how those board minutes are compiled, transmitted, reviewed, and then ultimately approved, okay? So that's again within the board rules. Next, seating arrangements. This is a topic of great discussion in several counties. I've seen vigorous debate about how people are seated. And we could avoid all of those debates if we just have a process within our board rules about how the tables are set, if you will, for board and committee meetings. So I'd really encourage counties to put within their board rules seating arrangements.
I just want to share what Polk County did because that was a hot topic. And they did a building remodel and added some very nice desks for all the county board supervisors, but they put in the rules that the county clerk will alternate the placement of the placards so that each time a supervisor comes into the county board meeting, they're going to be in a different section. So they're never in the same space, never seated by the same county board supervisors to the left or to their right. And that's actually been pretty darn effective. So for whatever that's worth.
Who decides where the placards go?
The county clerk.
So the county clerk is open to accepting bribes to place those placards in a certain spot. That's a dangerous position for the county clerk.
There was a joke that you knew whichever county board supervisor was not in the clerk's favor might be sat next to a particular other supervisor. And I mean, it was all in good fun, but.
That I can see that happening. All right, board member interest forms. We know that at the organizational meeting or shortly thereafter that we are going to seat committees and we're going to place supervisors on certain committees. How is it that the board chair or committee on committees or executive committee, however committees, how is it that those folks know who's interested in what committees? How is it that those responsible parties for appointments are going to make the right selections based upon interest, based upon talent, based upon a variety of factors? Well, I'd like to see a process in the board rules where people submit interest forms that discuss their qualifications or desires to sit and serve on certain committees. You don't have to have this. I mean, I think a lot of counties would say we don't want interest forms because we don't want it to become a political process, and that's okay. But I think from my perspective, and I think Malia agrees with me, is that more information is better. The more informed decision we can make when it comes to appointing committees, I think the better off that we're going to be in the long term. Any thoughts on that, Malia?
Well, the other option is waiting until they come to the initial county board meeting and announce their interest there and start, pitching for themselves to go onto a particular committee. So if you can forego that, it might shorten the length, and other county board supervisors might read the interest form and go, I didn't know this about this person, and I do think that they should be on that committee, and maybe I'll step down and release my tenure or whatever the process is. But I see the value in having that information available ahead of time.
The other thing that I will mention here, it's not in this template board rules, but it's something that I've talked about for years, and that is a desire to make sure that whoever is running for a board seat knows what they are getting into. When I say that, I mean, do we have a process that so when somebody takes out nomination papers to run for county board, do we hand them a job description? Do we hand them the county's current budget? Do we hand them the county's strategic plan? In other words, are we giving them the information so that when they take that seat on the county board, they know what they're getting into? And the pushback that I get on that is that everybody says, are you out of your mind? We actually want to encourage people to run for county board, not discourage them. And that's, I think, said in jest sometimes. I know it's said in jest a lot of times, but what are we doing to essentially set the table, if you will, to make sure that we are successful, whether it be in people that are running for county board, people that want to serve on committees, people that want to be officers, be board chair, board vice chair. What are we doing to make sure that we have the table set so that we have a firm understanding of their talents, of their background, of their experience, their desire to serve? And I think the more that we can do to encourage that, the better off we are long term. Conley asked the question, is there a standard or common use interest form being used by WCA as it relates to committee interest? The answer is no, there is no standard form. I would really encourage you to reach out to some of your colleagues across the state to see if they have forms that they really like. I know and I'll pick on them because I just know about it. Eau Claire County does a fantastic job with orientation, both at the nomination stage and also at the seating stage when it comes to county board members. When people take out nomination papers, they are provided a packet of information about the expectations for board members in Eau Claire County. And I know that Eau Claire County spent a lot of time discussing how they set that table for success. So I'd really encourage folks to reach out to Eau Claire County if they're interested in something like that. Board relationship with the executive, administrator, or administrative coordinator and department heads. This briefly gets into roles and relationships. And I know that roles and relationships and responsibilities are a comprehensive topic that takes hours to discuss. I get that. You can't put every element of roles, responsibilities, relationships within your board rules. That said, I think it's important that we, again, set the table for success and speak to the concept of the county board being a legislative body. Our executive, administrator, administrative coordinators serve in an administrative capacity, and that we don't have overlap between those responsibilities, that we have a clear delineation of roles within county government. And so within the board rules, we have a simple recitation of those roles and responsibilities. So again, when we look at this board rule, is it required by statute? No, not in the least. But I think that if you speak with other counties that have something like this in their board rules, you're going to see that it again establishes expectations as it relates to the relationship between board and executive administrator or administrative coordinator. I will tell you that Chippewa County has an example of, and I don't know if it's in their board rules or if it's simply a statement on policy that they have, as it relates to the role of the county board and the role of their county administrator. I use Chippewa County's example all the time in saying that this is a really good summary of all of the legal and organizational principles that come into play when we define roles and responsibilities within county government. And so I would really encourage folks to reach out to perhaps Chippewa County if they're looking for examples of a board rule that would fit into 2.11 right here. Joe asked a question quick. What about supervisors who are not assigned to any committees and other supervisors that are assigned to several committees? Joe, that's a great question. I've gotten that question from counties when they're putting together their board rules. Hey, should we make it mandatory that every supervisor has to serve on at least one committee? And that's something, if they say, yeah, we ought to make it mandatory, they put that right within their board rules. Malia, what does the law require in terms of committee assignments? Does the law require every board member to be assigned to a committee?
No, and the county board rules of order can delineate things like at least one committee, or to the best extent possible, committee assignments should be distributed with relative equality. So if you've got 15 board members and 5 committees, I mean, you're doing the math. So you know, depending upon how many committees you have, how many supervisors you have, because you can run the gamut as far as the numbers, determining how many committees each person should sit on, and their respective, you know, work outside of being a county board supervisor. In rural counties where you have committee meetings during the day, you know, attending a lot of committee meetings might be a hindrance to somebody who has another full-time job to run for county board, and then you're going to limit the folks that are interested. So being cognizant of those things when you're setting those requirements is something to contemplate as well.
Totally agree. Here we get into another area where self-organized status is important. Vacancies in the office of county board member. I've seen some counties try to define vacancy as, for example, missing 4 consecutive meetings. You miss 4 consecutive meetings, we're going to determine your office to be vacant. You can't do that. 17.03 of the statutes speaks to how a vacancy is caused, and we cannot, by local rule, modify that statutory provision. Again, getting back to that whole concept of precedence, our board rules cannot supersede state law. Okay, so vacancies are caused by the circumstances that are discussed in 17.03. How we fill those vacancies is up to us. And if we have self-organized status, we get to determine that process. If we don't have self-organized status, we are stuck with the process in 59.10(3)(e). So again, if you don't have an ordinance on the book saying we're self-organized, please do it. You may say, we like everything in 5910 right now, so we don't want to modify that. That's fine. At least get self-organized status, so if in 2 years you change your mind, you can adopt a board rule that defines how it is that you fill vacancies on the county board. Again, this is all italics and bracketed information, and so you don't have to do any of this. This is just an example of what we have seen in other counties that works. I'm going to call out Richland County here because I worked extensively with Richland County on their board rules in the past 8-9 months, and they have a really good, in my mind, process for declaring not for declaring a vacancy, but for filling a vacancy and saying, this is what we're going to do to advertise to fill that vacancy. So again, it's important that you choose self-organized status so you can utilize one of those alternative measures to fill a vacancy on county board. 2.13 is really important to me too, and this is going to be near and dear to Malia's heart. It's going to be near and dear to the heart of every corporation counsel out there. We don't want board supervisors having free rein over making statements to the public that are official statements of the county board. We want to confine those official statements to one person. That's the board chair. Nobody on the county board is authorized to make an official statement on the board's behalf, except the board chair, unless that person is delegated specific authority to do so by the full board, okay? It's important to have this in the board rules so that we have, again, the expectation, not only by the board members, but members of the public, so they understand that when somebody on the board is speaking, they are speaking as an individual board supervisor and not on behalf of the entire board. I know that, Malia, you and I have both dealt with situations where it's a PR nightmare when we have all sorts of statements that are out there, some of them conflicting about what the board authorized or didn't authorize. 2.14 is a bit of a controversial item as well in counties. When I say controversial, it doesn't mean that it's caused all sorts of issues, but it's caused all sorts of debate about what do we want to do in terms of allowing people who are not members of a committee into a closed session of a committee meeting if they're board members. We have a statute on the books that says that if you are a board member, you have a statutory right to attend committee meetings. We have a provision in Robert's rules that suggests we have the ability to exclude members of the board that aren't members of the committee from board meetings. And we have board rules that incorporate Robert's rules by reference that essentially connects the dot between that statutory provision and Robert's rules. So instead of having that grand debate about rules of procedure in Robert's rules, that grand debate about statute and what it allows or doesn't allow, let's put in our board rules a provision that speaks to this concept of attendance by board members who are not members of a committee at a committee closed session. The statutes contemplate having a board rule in place that speaks to this topic. So this is our admonition to everybody. Let's put this in our board rules. If we're going to allow board members in a closed session of every committee meeting, regardless of whether they're a member of that committee, let's put it in our board rules. I will tell you, I think Malia will tell you that that may not be a good idea because, for example, and this isn't just hypothetical, but for example, you may have a county board supervisor that is suing the county. Do we want that county board supervisor who is suing the county to be allowed in a closed session to talk about the strategy to be employed in that litigation? My answer is no. If you hire me or Malia to be at that meeting, we are going to tell you we are not having this discussion with the adverse party sitting in the room. That's not going to happen. So I think it's important that we have a rule on the books. Now, when it comes to invocation of that rule, is it a committee chair's sole discretion decision as to whether that person is excluded? Is it the committee chair's motion that has to be supported by a majority of the committee, 2/3 of the committee, unanimity of the committee? That's up to you. The rules of procedure that you want to have about how that process takes place is entirely up to your county as to how you want to deal with that. But the important takeaway is make sure that this rule is on the books. Section 3, county board officers. We have just 2 required officers on the county board. That's the board chair and vice chair. That doesn't mean that you are precluded from creating other offices. You can have a second vice chair. You can have a sergeant at arms if that's what you desire to do. if you do that, put those provisions, those positions, those offices in section 3 of your county board rules. Now, we have in here the county board chair duties under 3.01. The duties of the county board chair are defined in 5912 sub 1. We also know that there are a lot of things that county board chairs do above and beyond what's contained in 5912 sub 1. You may want to put some of that information right within your board rules. That's okay. Again, the Freedom Statute 5903 gives us the ability to add to supplement the duties of the county board chair beyond what's in 5912 sub 1. Now, we can't go contrary to 5912 sub 1. We can't say that, for example, we are going to rotate presiding officer responsibilities at county board meeting among the various supervisors. We can't do that because 5912 sub 1 says our board chair presides at all county board meetings, but we can certainly supplement what's contained in 5912 sub 1. Jeff asked a question: can a county board supervisor continue to serve if he or she works outside the state as long as the primary residence remains in the district? That's a good question, Jeff. If you look at Chapter 17 of the statute, 1703, defining vacancy, as long as they are a qualified elector within their district, then they have the ability to serve. It doesn't matter where they work. It matters for residence determinations. And the whole issue of residency, far beyond this discussion, there's been a lot of legal concerns raised over the years about this concept of residency, but as long as they're a qualified elector within their district, they can continue to serve. And qualified elector means they're a resident of their district. We have county board vice chair here in addition to chair. And again, county board vice chair is a position that is authorized and required by statute. And so again, if you have a series of duties that are incumbent upon your vice chair beyond what's required by 5912, then by all means put them in your board rules. Chairs and vice chairs of committees, there are different ways to address this. Again, how those appointments are made and so on. So it's up to you to define this. We are at 12:57, Sarah, and section 4 is where we get into the meat of the discussion on the rules of procedure. And I think that we have a lot of folks that would be really interested in our discussion on section 4, probably have a lot of questions they want to ask on section 4. And I do not want to give this section short shrift. And so I'm going to put you on the spot here and suggest that we tee this up for the November discussion of In the Boardroom. I know we were going to talk about town county zoning issues. I'm wondering if we don't put that on the December calendar for discussion and continue with the discussion of section 4 board rules during the November In the Boardroom. Sarah, do you have any thoughts on that?
Yeah, I mean, I agree with you, Andy. I was sitting here thinking as I was looking when we were on page 11, and I know there's 22 pages of the rules. And I was thinking we probably erred in not making this a two-part series.
I'm going to blame you, Sarah. I said this ought to be 2 parts. You said, no, Andy, talk
All
fast.
right.
You can get through this.
That's fine, Andy.
All right.
Me, that's okay.
Conley just agreed with us, Sarah. So I think we have a consensus here that we put this on the November In the Boardroom. So why don't we do that? And folks, obviously, I'll stay on here for a few minutes if you want to ask any further questions, but understand that we're going to tee this topic up for discussion again in November. Malia's made a promise that she's going to stick around despite how much I talk. She's going to stick around in November to talk about this further. Larry Berkey asked a question, Sarah, where can we download the template? I know that went out in Constant Contact. Is that available on our website too? WCA website?
That's a good question. I will make sure. Well, I have to see if we can, I will have to check to see whether or not we can attach it in Word format to our website. I know oftentimes you put stuff on your website in PDF. If not, Larry, I will make sure to get a copy to you and anybody else who wants a copy of it in Word format. And the only reason I'm suggesting Word format is then you can modify it for use in your county, which is why we put it out both in PDF and in Word format.
And I will tell you too, if you want to email me, I can get it to you as well. Malia and I will both be happy to send you whatever we have on this. So we can do that. But otherwise, let me make this suggestion too for the attendees is that think of the questions, take another look at the template and think of your questions. And let's try to get to those questions in a bit more detail then at the November In the Boardroom. But that's perfect timing. We can give thanks for board rules at our November In the Boardroom. Sarah, we set this up ideally.
Yeah, we're actually set for November 27th. I don't know what we were thinking because that's the day before Thanksgiving. So I will have to step away from cleaning and holiday cooking in which to do this, but that's okay.
That's okay. That's what we do. That's perfect. I love it. Well, good. All right. I don't know if you see Sarah's comment,
I do.
Sarah, so we can email
I
it to
did.
Sarah. But let's press pause on this discussion, and when we get back together on November 27th, we will have the opportunity to discuss in greater detail. Thank you, everybody, for your participation here. This is obviously an important topic, and we certainly appreciate the difficulty we have with some of these concepts. And so if you have questions, concerns, comments, want to chat about this, reach out to Sarah, reach out to Malia, reach out to me. This is a topic near and dear to our hearts, and we'd love to have that discussion. So until November, we
Absolutely.
will see everybody then.
All right, thanks, everyone.
You.